Okay, so that was recording. So just a quick intro, as Joanna was saying, Christy, Vinay and I, we are IP lawyers at HGF, but in fact the wider HGF, we're a firm of patent and trademark lawyers, so attorneys, so we can file patents, trademarks, designs, as well as advise on IP law. Okay, should we crack on?
Yep.
So the agenda, just very quickly, we're going to cover 4 areas. So what is IP? Why is it so valuable today, as it is? What are the different types of IP? And then we do a run through of, registered versus unregistered rights. Unregistered rights being as important, in our view, as registered rights, never to be undervalued. Okay, so what is intellectual property? Are we going on? Here we go. So the World IPO defines it as, can I just one moment, how do I remove, oh, hold on, let me just do something. There you go, that's better. So it's effectively creations of the mind, such as inventions, literary and artistic works, designs, symbols, names and images used in commerce. So intangible in many respects, but I often call IP tangible intangibles, and it covers everything from Coca-Cola's logo, the design of Crocs shoes, vaccines, music, and the list could go on and on. So why is IP so valuable today?
So I'll be taking over from here, guys.
Yeah.
You can see over here it's a graph, which is basically intangible versus tangible assets for the components of the S&P 500's market value over 1975 all the way to 2020. What's interesting to note here is in 1975, it started out with intangible assets covering 17% of the entire market value. However, you can see in 2020, it's come up to 90%. Now, the difference between tangible and intangible assets are, to keep it simple, to keep it brief, tangible assets are things such as buildings, factories, your inventory, cash, equipment, and so forth, whereas the intangibles are things such as brand value, customer data, product design, patents, and so forth. Moving on to what we wanted to do was show you deals of note within IP itself. So, for example, Kodak Eastman Kodak built its entire business empire on the strength of its camera film. But when consumers switched to digital cameras, as we have all done, Eastman Kodak tried to make a move into the digital camera market, but it was a little too late. So what actually ended up happening in the US is that Eastman Kodak realized that they were actually having to file for bankruptcy. And in order to make sure that they were able to go with that charge, they had to sell their entire patent portfolio to a conglomerate that included Apple, Google, and Microsoft. The expirations as well, as we'll go on to see, since patent rights are time barred, their expiration dates are extremely important in whichever industry they operate in. In fact, from 2007 to 2016, the 10 biggest drugs that were making the most revenue in the market, which accounted for more than $915 billion in sales, all lost their protections. The other example over here for trademark infringement, copyright, and geofabrics patent infringement action is to just show you that, to illustrate not only how valuable IP is for a company, but also the value of the scope of protections offered by this IP. For example, Adidas was able to recoup over 300 million from Payless for violation of their trademark. And Ed Sheeran was able to recoup over 900,000 pounds for a claim that was initially laid against him.
So I'm now going to talk a little bit about the various different types of IP, starting off with an example of a product that we're all very familiar with, and thinking about the different types of IP that apply to that particular product. So taking this Nescafe Gold Blend as an example, it's important to think about all the things that we're looking at when we see this product. So we're seeing the packaging of and the design of that packaging. We're seeing a brand and different text around that brand. We can see that there's coffee inside of it, which has been made, as we know, from more ingredients in different ways, and the visual of the label itself. And finally, just the formulation is taken to get to this final product. And each of these kind of elements of the product apply to different IP rights, which I've said that in the next slide. So the labels, the various labels, and the brand itself, Nescafe, all relates to trademark protection, which we'll talk a bit more about during the presentation. The packaging is a registered design, again, something that we're going to cover. There's copyright protection potentially in the label, and also potentially in the ingredients. And then also just thinking about, and this is something we touch on quite a bit, different know-how and trade secrets, and kind of the confidential information that underpins the product itself. And finally, any potential patent protection, which could apply to any kind of product like this, which is novel and inventive. And that these are all kind of the key topics that we're going to be talking about during the course of the presentation. But this slide's really just to iterate how IP kind of touches every part of our lives, and we see it all the time potentially without even realizing it. So moving on to the next slide, I'm going to talk specifically about trademarks and what trademarks are. So a trademark is a recognizable mark capable of distinguishing goods and or services of one undertaking from another undertaking. Oh, I disappeared there, I am. So that is the key point to take away about trademarks. Again, something that we see in everyday life, but it's to think a bit more about what seeing certain logo or branding means to us and what that indicates to us about the product or service that we're purchasing. So a trademark can be any sign which is capable of really being recorded on the trademark register, and one that the public can determine clear and precise subject matter from. And we talk a bit more about various types of trademark on the next slide, but a trademark can be a slogan, it can be a logo, it can be a word, a phrase, a symbol, or a smell. And we've put up some examples of key trademarks that you'll have seen. So Nike's famous "Just Do It" slogan, the Guinness harp. And the other image on the slide is the Bass trademark, which is one of the oldest trademarks in the UK. And the key point and the key reason why we've included that on the slide is to iterate that a trademark, once registered, provided it's renewed every 10 years, can really exist on the register. Obviously, it's always subject to challenge, but can exist on the register in perpetuity. So trademark protection of all of the rights really has true kind of longevity to it. So we've gone to the next slide. This is some examples of kind of trademark stats you will inevitably recognize, but also just to demonstrate kind of the different ways that trademarks can appear on the register and the different types of things that can be trademarked. So we've got colour, which is of interest because it's difficult to attribute, I think, a colour to a specific undertaking and a specific good or service. But there have been a number of successful colour registrations now, which is very important. Provided, of course, that they are registered within specific goods and services. So Louboutin, for example, registering the red sole of the shoe, which is infamous, very, very famous, I should say, and the Heinz colour as well, which attributed to baked beans. You've got the shape of packaging, and we've included Toblerone as an example because it's very, it's iconic. Gestures, so the Asda advert that we'll all be familiar with is the tap on the back of the jeans product. We've got smells, internet domains, and then we've got a sound which Vinay is going to play for you, which you ought to recognise. So just to reiterate, as long as the trademark is capable of being registered, it's capable of discernment, and it's distinguished, then there's always at least an opportunity that it will meet the requirements for registration. And under the important points to note, we've put pre-filing searches are essential. And this is a key point, because when a company is starting out and looking to register a brand and develop a brand, and they go to seek to file a trademark, it's important really to check the register for what already exists. And there's a lot on the register. The register is very full. And look at what's already been taken in relation to the goods and services that you wish to operate within. Then there's a number of things that you can do in response. You may be looking to clear the way, so you may be looking to get other marks off the register, or you may wish to move away from them entirely and try and come up with something innovative that doesn't already appear on the register. But in doing those searches, you can really find out what's out there, and make sure you don't run into trouble and infringe on somebody else's trademark. I already spoke briefly about the term of a trademark. So provided you do that renewal every 10 years, there really is an opportunity to maintain your brand, forever in theory. The brand's always going to be subject to challenge potentially, but having the brand, the registration in place, it will stay that way provided you're renewing. And then we've just put these little symbols at the bottom, because I think it's a common misconception that where there's a little TM beside the mark, that the mark's actually been registered, but it's not the case. So if there's a little TM, that indicates an unregistered trademark. And unregistered trademarks are something I'll talk about a little bit more later, but the R in a circle is to indicate to the market that is a registered trademark. So that's slide. And I'll hand over to Marie to speak about patents.
Thanks, Christy. So patents, I think this is one of the areas that may be relatively familiar to you. So this is a monopoly right for new and novel inventions. And it provides a time-limited monopoly, effectively in exchange for a full disclosure of an invention. And it'll come out later in this session, just what the trade-off is really. So for your patent, you get your 20-year monopoly, you get your protection. However, the trade-off is that you're telling the world about how you go about your manufacturing process, or how your product works. And in that regard, you may actually think about keeping information confidential or protect it, as a trade secret, because as long as it remains confidential, then that protection lasts much longer than a patent. And we're going to come onto this later on in the talk. So that's always the trade-off, really. But what can be patented? It's inventions which are novel, that are inventive, that are industrially applicable, and they don't fall under any of the exclusions. And it's a very, as you can imagine, incredibly active area and covers a very wide range of products. The first two, top left and top right, are somewhat older examples of what has been covered in the past by patents. And Vinay is going to talk about some of the later examples. But one thing I would say, just as with trademarks, doing pre-application searches in relation to filing patents is absolutely critical. Otherwise, you can waste money in terms of filing an application only to have it bounced or be subject to a very negative examiner's report early in its life. And also the whole patenting process is quite strategic. And again, some of the examples that Vinny will highlight in a moment, they can be used as defensive as well as offensive intellectual property rights. So defensive in the sense of you want to protect your intellectual property, you want to protect your invention. However, those companies with deep pockets and who are acting in a more strategic way can actually use it to actually file patents, and may actually never use the patent, but it just makes life more difficult for the competitors it bars them from a particular product, invention or process use. And it makes their life more difficult because they've got to come up with design arounds for a particular patent or family of patents. So just over to Vinny to talk about those examples at the bottom of the screen and on the next page.
Yeah, thanks, Marie. The top two examples are just to show you the scope or the spectrum on which patents can operate. For example, MRI technology is something that we are all very well versed with, operates almost in the same space that an invention for a pet umbrella and combined pet leash works in. So it's interesting to know how both of them are protected by sort of the same mechanism. And bottom left, I've shown an example of a Marcuse structure. This is usually a representation of chemical structures often used in patent applications with respect to pharmaceutical industry. And the bottom right was basically a question that I wanted to ask all of you. It's something I found quite interesting, which was a flexible display device patent that was filed by a certain company in 2011. And I'd ask all of you to just think about different companies that we all know, phone companies that operate in the space with foldable tech, and move on to the next slide. In fact, the patent that I was talking about, the patent that was on the bottom right, was the first patent filed by Apple in 2011 for a foldable technology. It's Apple's most cited patent application for oppositions relating to foldable tech. The Apple anecdote, as you can see from the graph below, you can see that Apple's foldable phone patents have really seen a big steep increase post 2019. You can see the year 2020 has 11 patent applications cited, and this is not only to indicate the sort of ramping pace that Apple's taking in order to produce a foldable phone, but it also has other takeaways from it. For example, the fact that 2020 marked the year that the Moto Razr touchscreen first came out and Samsung's first flip phone came out. In addition, it's also to show you that from 2011 all the way to 2023, there has still not been any foldable technology that has been released by Apple. This is to show that from filing all the way to commercialization of any sort of product is an extremely long process. Furthermore, the number of patent applications filed by Apple in the absence of any sort of foldable phone today shows that, borrowing from Marie's earlier point, there's different tactical reasons that any sort of firm might use a patent. It can be defensive, it can be offensive. And since there's no real necessity for Apple to use its patents in actual products, there are plenty of other reasons that they still might pursue this outside of tech. One big reason is to ensure that other firms can't take the same approach to foldable tech. You can see it as insurance for the future. Or another reason could also be that Apple can later on down the line sell these patents to manufacturers or to licensors. And yeah, Maria, I'd like to give you back on what can be patented.
Yeah, thanks for that, Vinny. So just to sort of close down on patents now, that they are territorial rights and they're only applicable in the country to which the patent has been filed or granted. And that's critical. So if you've got a UK patent, you can't sue someone for patent infringement, say in France or in Germany. It's territorial. It's a territorially bound right, and it lasts, as I said earlier, for 20 years from the filing date of the patent application. So what happens after the patent expires? Well, all the rights granted to the patent holder expire with it. And that patent holder can no longer prevent others from making, using, or selling the invention or using a process. And that's something important to bear in mind if you ever get to the point where you're licensing patents. Try, if you can, to bundle up patents with some form of know-how, because on the expiry of the patent, you may still be able to extract a license fee for any ongoing know-how. Alternatively, if you're a licensee, just bear in mind and keep a very close eye if you're a subject of a patent license. Just monitor very closely the expiry date of the patent or patents, the subject of the license, because on that expiry date, the royalties should cease. unless you've contractually agreed otherwise. Okay, now on to the next patent and next slide. This is registered designs. This is all now. We're moving on to IP that protects the appearance of an article as opposed to how it works and operates. So it protects the external appearance of products. So that includes the shape of the product, surface decoration, configuration, or how different parts of a design are arranged together, and color or pattern. So it's quite a wide-ranging intellectual property rights. Again, these are territorial rights. You can get, UK, in terms of registered designs, you get UK registered designs and European registered designs. And the European registered design covers a very broad European territory. It doesn't cover the UK anymore. So if you've currently got a EU or community registered design, you really need to clone that into a UK registered design. And any design that is subject to registration, it's got to meet certain criteria. It has to be novel. It needs to possess individual character. And it must not be solely dictated by technical function. And on the right-hand side, we give some examples of what a registered design can be. So you've got the design of the Dyson supersonic hairdryer. And in fact, Dyson is one of the companies, one of the many companies that invest a lot of money in not only R&D, but protecting it. And so they have an awful lot, not only patents, but an awful lot of registered designs. You've got the shape of a Formula One car. Alternatively, you can have elements of that shape of the car. And I think it's an interesting point to bear in mind, both community and UK registered designs. They are relatively cheap to obtain, and there is no, and the registries do very little searching before granting it. So they're pretty quick to get, pretty easy to obtain, and quite cheap as well. And they also last for a period of 25 years in the UK and in the community. And that's subject to the protection being renewed every 5 years. And as litigators, I can certainly say that it can be very difficult to overturn registered designs or defend registered design claims. There's an awful lot of work that's needed to be done in order to overturn them, but typically you're out there looking for prior art. We've got some further examples here of registered designs, but one thing, and these are sort of very much consumer products, and I'll go through them in a moment, but one thing I would really point out is that registered designs apply also to what we would call more industrial products. So for instance, although I don't think we've got it on these slides, we've recently been before the Court of First Instance of the European Court, the CJEU, where we were effectively, we had overturned a registered design for a fence post, a security fence post. And we had won on appeal at the European IPO. The owner of that fence post design took it to the Court of First Instance and overturned the EU IPO's appeal decision. So that, to me, that is a perfect example of the extent to which, well, how important registered designs are, how much they can protect your product, and it's not just consumer products, and also, you know, it can be pretty difficult to invalidate a third-party design. So it's certainly worthwhile thinking about getting registered designs for your products. So these are just very quickly, just look at these three examples. In regard to the Lambretta tops there, the colours were held to be surface decoration, which is interesting. And then we've got the Procter & Gamble case, which was, I believe, the first registered design case in the UK under the new regime. And Procter & Gamble had figure 1 that was their product, and you might have seen it on supermarket shelves. They initially won in the High Court, but the decision was later overturned as the Court of Appeal held that the Airwick product on the right was more like a lizard's head, whereas Procter and Gamble's product all looked like a lizard's head. So there you go. That's the extent to which you have to analyse registered designs if you're seeking to enforce them and, more importantly, defend or overturn them. And then a number of you may be very familiar with the trunky product. I certainly do. I've tripped over plenty of them in airport lounges. And here you've got the trunky registered design at the top, and then you have got the copy, if you like, the kiddie case one below. And ultimately, again, at the Court of Appeal, the trunky design registration was confirmed not to be infringed. And you have to, in that case, ignore all the surface decoration and all of the character features of the kiddie case, and just look at the shape and compare the shape, because that is what that particular registered design was protecting. Okay, I'm going to now pass back to Christy.
Excuse me, absolutely, yeah. So I was going to talk briefly about unregistered designs, of which there are a few IP rights. So it's going to cover confidential information and trade secrets, copyrights, unregistered design rights, and unregistered trademarks, and the common law right that we refer to as passing off. And as indicated by this kind of bubble below, a lot of companies do choose to rely on unregistered rights, largely because in doing so, they don't have to spend money in order to get the right, because they're not going through the registration and examination process that's required by things like patents, which can be expensive to file and prosecute. So just moving on. We have confidential information, something which I think everybody is familiar with, which is protectable under common law. And what we mean by that is there's not specific legislation necessarily that you would rely on in order to protect your confidential information. What has happened is that there's a body of case law that's been developed in the courts that protects confidential information, such that if your confidential information was somehow breached or disclosed against your will, you'd have this body of case law that you could rely on to enforce your rights. So that's quite an interesting part of confidential information law. The key thing to stress about confidential information is that it really can be presented in any kind of form of expression or mode. So the common one that we're familiar with is GDPR. So say customer information. So your company might have a customer database, which includes lots of information for contacting the customer or data about things that they've purchased, things like that. And that would be a good example of confidential information. The other is algorithms, and the other is salaries, employee pay. So I could talk about different types of confidential information all day because it's so broad. But just to give you a flavour of the types of things we're talking about, and the real test of confidential information is whether or not it's secret, and by that we just mean it's not been held in the public domain. So for that information to be protectable under the law of confidentiality, it needs to have a necessary quality of confidence. It needs to be provided in circumstances which give rise to an obligation of confidence, and the maintenance of that confidentiality is critical. So if that information is disclosed into the public the next day, it's no longer confidential information. And that kind of test right there is assessed objectively by the court, and it's a standing in the shoes of somebody else test with the person who had received the confidential information have understood that information was confidential in the circumstances. So just moving on to trade secrets, and this is an interesting point, and it comes up a lot because there's quite a lot of crossover between confidential information and trade secrets. So I'll try and explain the key differences. I suppose I'd start by saying all trade secrets are confidential information. They're kind of and more. So confidential information, it has a secret element that we talked about before, but trade secrets specifically have intrinsic commercial value to the company and are subject to reasonable protection measures. And those protection measures can take different shapes and forms. So you've kind of got your classic technical protection measures, so password protected documents, security that doesn't allow you to download a certain document. Perhaps that information is only disclosable to certain people within the company. Perhaps the company conducts exit interviews to ensure that everybody knows where the trade secrets within the company are. So it's a really series of measures that companies take to take that step further to ensure that the information benefits from trade secret protection and not just confidential information protection. So the sort of three key components for a trade secret are that it's secret, that it has that commercial value that I was talking about previously. And that's a point of distinguish between confidential information is you might have confidential information that's not intrinsically valuable at all. And that kind of information isn't what we're looking for when we're looking at protecting trade secrets. And those protection measures that I just talked about. And we've put up a couple of examples on the screen. So we've got KFC's, I think it's 7 secret spices, the Google algorithm, which is a famous trade secret, and the Listerine ingredients too. And one thing we always stress to clients is that, and they say, well, how can I stop somebody else from copying my trade secret? And the answer is, well, if KFC's 7 secret spices is copied, somebody successfully reproduces it, that's fine. So you can't protect against reverse engineering in that respect. The key thing with a trade secret is keeping it secret. So if somebody's reverse engineered it, sorry, but you're probably not benefiting from trade secret protection. And the other thing to stress about trade secrets just briefly is that in addition to this kind of breach of confidence law that I talked about previously under common law, trade secrets also benefits from the Trade Secrets Directive, which is actually a kind of codified piece of legislation. So there's some additional layers of protection that come together with reliance on the directive. So just moving on now to another unregistered right on this kind of line of thinking is copyright protection. So copyright protection protects creative works. And what we're looking for when we're talking about copyright protection is original works. And there's a closed list set out within the Acts of the types of things that can be protected by copyright law. And that includes dramatic works, musical works, artistic works, graphics, broadcasts, software, photography. I mean, it's a long list. But all essentially creative, and the key thing to note is that the work needs to be original. I should probably start by saying that the bar for originality for copyright is quite low. The blue jeans on screen are part of quite a famous case where a European court said that the blue jeans were an original work, just to give you a kind of flavour of that threshold being quite low. The good news is it comes into effect automatically, so there's no need to go through any kind of registration process. And in obtaining copyright, which is automatic, you're able to prevent somebody else from issuing copies of your work, performing your work to the public, making adaptations, and more. So it's a really beneficial right. We've put remember, sometimes protected by a C, in line with our trademark R. And some kind of fun facts, I suppose, about copyright is that most employers do own their employees' copyright where it's created in the normal course of their duties at work. And that's something that's implied by law. So even if that wasn't set out in contract, which it almost inevitably is, it would apply. Industrial designs are often excluded, and that's because there's opportunity to protect industrial designs under design law, as Marie's talked about previously, and I'll touch on briefly in a moment. There is the opportunity to protect shapes, and we've put up an example of the Brompton bicycle. And the courts really said that as long as there's room for free and creative choices, more functional, shapely designs like the Brompton bicycle can benefit from copyright protection and that lower originality threshold. And I'll just conclude this slide by noting that software is protectable by copyright, and it's something that clients come to a lot, which is why we've got our kind of Apple and Microsoft icons and so on. So that's always important to bear in mind. I'm going to hand over to Marie, who's going to talk briefly about unregistered design.
Thanks, Christy. So, unregistered designs. I'm covering this because I did the registered design element of this talk, and now this is the unregistered. Just like copyright, this is a right that will arise automatically, provided qualifying criteria are met. And this is more in relation to a product design as opposed to copyright, where it's literary, artistic works and the like. And really, unregistered design right effectively replaced the old copyright, and it was a long time ago, up to 1989. You could protect 3D articles, industrial products with copyright protection, but that disappeared in 1989 on the basis that it just created too much of a monopoly, and it stunted competition and creativity in industrial design and the design of products, basically. So in the UK, unregistered design right, it subsists in 3D design, so your product designs. As I said, it arises as of right, provided it's an original design. And by original, we mean that it's a design that isn't commonplace at the time of its creation. And in order to find out, ascertain is something commonplace at the time of its creation, you need to do an analysis of what was available in the market, generally known in the market, or the relevant sector of the market at the time. And just putting there some examples of a hot water of articles that can attract unregistered design right. Now, unregistered design right will not extend to surface decoration. And so we've put the example of a hot water bottle up there. Now, that sort of hot water bottle will have, you can see, has a pattern on the front, but it is a raised pattern. And the question there would be, is that surface decoration? Is that feature there for decorative purposes? Or is it actually there to reinforce the strength of the water bottle and maybe improve the penetration of water, of the heat out of the water bottle? And these are the sort of things you need to think about. In my view, this would be protectable, the whole design, or rather that raised element, if it wasn't commonplace, as an unregistered design right, because I don't think that's surface decoration, provided it's 3D. I think it is actually, it's got a function, if you like, and it isn't surface decoration. And then we just set out there an example of a case, what of those elements is surface decoration and what is actually having a function almost, if you like. And with decorative items such as these, particularly in court cases, you can have a lot of argument as to what amounts to surface decoration as opposed to actual elements of a design, basically. So in the UK, unregistered design lasts for 15 years from the date of creation of the design. But generally speaking, when you're dealing with designs of products that are developed and sold in the marketplace, the rule is the unregistered design right. It lasts for 10 years after the first marketing of the product. And in that last 5 years of the life of the unregistered design right, licenses of rights are available. So a third party could approach you for a right to use, for a license to use your product design. However, that's going to have to be subject to agreement of license terms on reasonable terms. So it's not, you don't just rock up and say, I want a license of right of your IP right. And there are a number of exceptions and qualifying criteria. So if you have got a product that has been created and designed in China, and then you're selling it in the UK, you cannot claim unregistered design right. In that, you have to look at the nationality. So nationality of the designer is relevant. And it's also important to keep iterations of your design, because a base product, a product, that may have unregistered design right protection, if you update that product at any point, or elements of that product, that can attract fresh, new, unregistered design rights. So if you are developing your product design, unregistered design right can also develop with the new elements of the product design, provided it meets the qualifying criteria. There are various other exclusions regarding elements of a design that must fit or must match other products in order for them to work. For instance, a 3-pin plug, or rather the plug socket, that would be the must fit exclusion. So anything that has to, if the design of a product is dictated by another product, the shape of another product, into which it's got to fit or it's got to work around, then those elements will not be protected by design right protection. So, do we have another slide after this one of any more examples, or that's it?
Yeah.
Oh, great. So there we go. We've spoken about your designs, consumer products, industrial designs that will be protected by potentially a registered design, but also unregistered design right as well. I'm now passing back to Christy on passing off.
Yeah, this is the last IP right that we really wanted to cover in this unregistered rights section, and actually for the whole of the talk. Passing off is a strictly UK common law right, again, which is founded in case law, which is very beneficial and something our clients rely on a lot. So where you have a product or get-up or branding, or an unregistered trademark, say a brand, but it's not been registered as a trademark, and that thing benefits from goodwill in the UK, and a competitor is making some sort of a misrepresentation that could mislead the product into thinking that either it comes from your company, your business, or that there's a commercial association between them and your company. And there's a risk of damage resulting from that misrepresentation. You could well have a claim in passing off. And that sort of 3-limb test was established in this Reckitt and Coleman case, which is kind of known in IP law as the Jif Lemon case. And you can see how that happened, where the get-up of the product is so similar that consumers in the marketplace could well have been deceived into thinking it came from the same undertaking. And they were successful in that case. And that case has really founded the test for passing off, and it's relied on often. The other case that we've got on the screen is Moroccan oil, where you've got the original Moroccan oil product and then an Aldi lookalike product. And as you can imagine, Aldi and Lidl and brands similar, who often produce lookalike products as part of their business model, find themselves in court quite a bit with respect to passing off, and some of you may have seen the famous cases that relate to those sorts of issues. So there's a few kind of advantages and disadvantages to highlight. Start with the disadvantages. So protection is only available when you actually go to enforce, through pre-action correspondence or through the courts, because it's really for the court to determine whether or not passing off can apply and whether or not the right exists and subsists. So there can be quite a high burden of proof on the claimant to establish that they had goodwill in the first place. And without goodwill, there's really no risk of damage. So that's another quite high burden of proof. And often it's the case that if you've got evidence of people actually being deceived, that can be really helpful and persuasive in court cases in that sense. And that difficulty in establishing goodwill I just mentioned. But the advantages are that it can prevent visually similar branding, where you may not be able to get trademark protection very easily for it, but there's still that risk of copying and deception on the marketplace, which is why it's often tied together with a trademark claim passing off where it's appropriate. And the other advantage, again, as with our other unregistered rights, is that there's no prosecution costs, no examination, no process to go through to get there. So as long as you've got that goodwill, and that's not necessarily an easy burden to get past, but as long as you've got goodwill, then you may well have a case in passing off. So that sort of takes us to the end of our slideshow and the various rights that we've covered. Happy to open the floor, Joanna, to any questions.
Yes, if anybody's got any questions, please either sort of put your virtual hand up or unmute yourself, because we've still got sort of 20 people online, so we should have one or two. I've got a quick question I'm going to ask first. There was a graph early on which Vinay talked about, which showed the changes in the stock market value of companies, depending on how the value of the IP in a company had changed over time. What's that down to? Why is it now 90% of the value instead of 17?
That's a very good question, Joanna. And actually, I'd say, it's very interesting to see that in the context of two market crashes from 2000 and 2008 as well, we've still managed to see such a big rise in intangible assets. I'd say that is primarily to do with the fact that we're working within the age of technology, right? So in terms of what are considered valuable assets today compared to 1975, there's a very different definition to it. Whereas labor, for example, was seen as an asset before, now most of the labor is automated, for example. So all of a sudden, a machine or an algorithm that helps you manufacture products in a certain way are going to be seen as having higher value, and there's more value that can be ascribed or attached to a certain product or a certain software. With 4G, 5G revolution that has come up, and the looming AI sort of revolution as well, which we all know about with ChatGPT on the horizon, I think potential for new technologies to really boost how much intangible assets are worth in the market is just going to further increase.
And I think it's there's the really good points, Vinay. I think as well, it's also worth bearing in mind just market trends, really. So sitting here in the Midlands, we act for a number of companies, and there are many companies out there, say in automotive or in an aerospace sector or new energy sectors, that years ago would have developed the technology and gone into manufacturing it, whereas now there are so many companies there who will develop technology and then look to license it. So the intellectual property, the R&D output, that is the intrinsic value of their business, and they don't want to invest and have the cost of plant, equipment, factories, staff to create something. And so, and I think as well, it's also other trends in the market where, everyone is looking for the next best thing, aren't they? In addition to all the software advances. So I think that's, and also the fact that people are valuing and appreciating IP more and more. I think that also has an impact on this.
I mean, I was wondering, there's been a few cases in recent years of people like David Bowie selling his rights to his back catalogue. So things like, I mean, that's presumably that's just copyright, but he's selling rights for millions and millions of dollars. So is this sort of, is copyright one of the more valuable rights, or is that just a sort of specific to creative industries?
I think that's just specific to creative industries, obviously software houses as well.
Right.
You know, software is just embedded in just about everything, isn't it, in terms of things we use, things used in production processes and the like. But I think as well this, and when you see this change in company valuations, you can therefore understand why there is so much strategic IP protection going on. So as Vinay was showing earlier, how Apple used its, you know, its bank of patent applications to make life very difficult for Samsung.
Yeah, that one caught my eye actually, because I used to work in telecoms. So Apple has not licensed other companies to use their folding technology. They've just created a bank of patents, which means other people can't do it.
Correct.
They've got to find a different solution.
Yeah.
Wow.
Yeah.
There's absolutely no obligation to use the patent that you filed. So that kind of obstructive behaviour is more than possible.
So thank you very much to HGF for today's session. And yeah, keep in touch.
Thank you. Bye-bye.
Thank you.
Thank you very much.
Bye.